Hello, this is Amarjot Singh. I'm ICCRC consultant based in Edmonton and Alberta. And in the series of bringing cases to exemplify what mistakes are causing some refusal in some cases so that people can understand, people can avoid those mistakes in their own cases. This is the second case I'm about to discuss with you. This case is about express entry refusal, and you will see what were the causes, what did the judge say when the applicant decided to appeal. As you can see on the screen, it's a federal court decision, Joseph versus Canada. You can see the date and the citation number, the file number. If you copy and paste and put this on Google and search on your own, you can get the whole case. They're about 9 pages, and you can read word by word if you choose to, and you can follow exactly to the letter what they were saying. So let's dive into the case. This is a fairly new, not old. This is March 7th, and the Sarah Oluwataminu Joseph was a Canada to the Minister of Citizenship and Immigration. So this is I've highlighted some things that I wanted to share with you. So this is an application for judicial review of a visa officer refusal decision dated July 2017, indicating that Joseph's application for PRE was refused due to incompleteness. I have talked about completeness of the application many times also, especially in express entry, where the express entry application system generates a checklist which you have to complete. So if the checklist is saying that you have to give a certain document, and if you fail to, the visa officer will deny it. There is no question about, that they will ask you second time or third time, please give us this document, otherwise we will reject you. No, they will not give you advance notice. They will reject because the application is incomplete. So this case is exactly about incomplete application, and you will see what happened. In the yellow, I have highlighted specifically the application did not include the police certificate from the UK, where she resided cumulatively for 6 months. So the PCC was not provided. So that's the main reason why the application was incomplete, and it was rejected. Take a look at some information here on the screen. What is the background? The applicant is a citizen of Nigeria who, after creating an online express entry profile with IRCC, was accepted into the express entry pool, There's a lot of information. But look at the highlighted in the yellow. It also encouraged her to begin to assemble the necessary documents as soon as possible. So among the necessary documents which needs to be submitted was also the PCC, which I think she forgot. We will see what happened. Why did she not give the PCC? So the applicant is raising these issues in the highlighted in the yellow. A, did the officer breach the principles of natural justice in failing to provide adequate opportunity to submit a police certificate? In plain English, the officer should have reminded me, please give me the PCC again, I'm about to reject, something like this. Number B, did the officer err in failing to exercise discretion? Does the officer has a discretion to use whether, if the PCC was not given, I can still continue processing the application and maybe take it all the way to approval? Is that the discretion that the applicant is expecting for the officer? We will see. Number C, was the officer decision reasonable? We will see that. All right. So there's some mention about some cases here. The applicant, what is the applicant saying? And the applicant is Laura. I've just mentioned some thing here. This is number 1. So the applicant is saying that the officer breached the principles of natural justice by failing to provide an adequate opportunity to submit. So the applicant is saying, look, officer, you should have reminded me. You didn't remind me, I forgot, and that's it. And the application went through. Oh, look, it's not my mistake, it's your mistake. You should have reminded me. So that's what the claim is. There was a situation in this application where the officer had sent her a request to provide details about her travel history and background information. So I think she was thinking that maybe because the officer had asked her to provide information in a different context, that could have also be used to have been reminding her to say, look, give me the PCC again. All right, so that's what she's thinking, but we will see whether the judge agrees or not. All right, so look at here what else is going on. So the judge, you know, the judge has to in the green. The green highlight is what the judge is saying, and what I also agree actually to the side of the law. The legal and the procedural framework governing this matter is clear and simple. Applications must be complete in supplying all the information. So there's no, you know, there's no leeway on something to say, look, no, it cannot be complete. You know, you can just let it go. No, the applications must be complete. So that's the procedure. That's the law. Let's read a little bit here. In express entry, an applicant must provide all information and any documents an officer requires. An incomplete application is to be returned to the applicant if the applications are not met. It's very clear. And applications are assessed for completeness upfront. An application found to be incomplete should be rejected as for R10, which is very, very clear. It's right here. Furthermore, the onus is on the applicant to provide a complete application within the allocated timelines. Of course, if you exceed that, unless you tell them, you know, whether you're trying and you can't get the PCC, you know, I think you're looking for some refusal all right there. So the applicant further argues that in the case, there was another case called Duran versus Canada, and look at this case of Duran versus Canada should be a persuasive authority in support of her argument that she was denied procedure fairness. So in that case, that was, we will see the circumstances of the case later, but in that case, that the judge sided with the applicant saying that no, yes, you were denied procedure fairness and we will have to redetermine or re-adjudicate your case. So, but in this case, the Duran versus Canada does not compare well with this case itself, because, and you will see, Duran also involved an applicant in an express entry program whose application was rejected because he provided a PCC from the National Police Commission of Philippines rather than from NBI as required. So in Duran case, the Duran actually did supply something, even though it was possibly wrong certificate, but he did provide something. But in our case, nothing was provided. So as you see, Justice Rither's South Court found that Mr. Duran had been denied procedure fairness with application rejected. Blah blah. Applicant I should follow. Okay, so it's not comparable. That case is not comparable with this, as you can read the information here on this case. However, I find the decision Duran, like all cases involving claims of procedure fairness, turns on particular facts. In that case, the applicant had indicated to the respondent that he was having difficulty uploading his documents to online system, and indicated he had uploaded his PC from the Philippines, although he was having difficulty. So it's not a comparable case, all right. So this doesn't fly at all. So you will see, as he says here, the judge says clearly, in the case before me, the record is quite different. It's very clear. So it is clear the applicant was advised clearly in the process. Yeah, so that's fine. So again, her claim is that she did not submit the required PCs due to inadvertence. Inadvertence is something like, you know, by mistake, I forgot or something. And that it was unfair of the officer to summarily reject her application without alerting her that she was missing an document. No. The immigration office has no obligation to give you advance notice. So please send me the PCC, otherwise I'm going to reject the application. No, they don't have to do that. So I think the applicant is dreaming. The law is clear. The onus lies on the applicant to submit a complete application. There's no duty on an officer to remind applicant. Of course, I agree. And that's it. The things are very clear, very clear. So the officer error in failing to exercise discretion, I don't think so. You know, there's no discretion to be used here. And in a different case where the applicant says, you know, Fernandez versus Canada, you know, it did happen. In that case, the discretion was used. But in that case also is not comparable with this, because in that case, Mr. Fernandez did not even have the points. So that's a different comparison altogether. So this case does not, you know, if you can see on the green, in Fernandez, the application was rejected because the applicant did not have the sufficient points to qualify as a skilled worker. So that doesn't compare well with this case. Of course, it's comparing apples and oranges. So that's what it is. Was the officer's decision reasonable? Of course it is reasonable, and you can read the definition of reasonable is concerned mostly with the existence of justification, transparency, and intelligibility within the decision-making process. Yes, of course it is. Absolutely. So the conclusion is very clear. For these reasons, this application for review is dismissed. No question for certification proposed, and I find no serious question of general importance. So that's what it is. The application, right here, the application for judicial review is dismissed. There's no serious question to be certified, and that is very clear all the way through. You can see the docket number, the name was his Minister of Citizenship and Immigration, and all the way through. If you want to see the lawyers who were representing them also, you can see them as well. Top Market Attorneys LLP somewhere in Ontario. So guys, it's very clear. Just giving a summary in just one line, right? One line. There is no obligation from the immigration office or any visa officer to remind you that please give us these documents. The checklist generated is enough advance notice that this is what has to be done by you. Please do it in that allocated time. If you don't, the application is likely to be refused. So, please make sure that you learn from this, and it's very clear. I mean, if you don't do this, your application will be rejected, and you have to start all over. All right. Thank you very much for watching, and share with your friends and let other people know. I'll be coming up with a new case and a different cause of rejection, and then we'll talk more about these refusals. Thank you.